I'll just get my notebook. Hold on a minute.
Oh, that'd be fantastic. Thank you. Okay. I mean, I'm recording it if that's okay as well. Okay. Jane says she can't get in. I have no idea why. Is anyone able to kind of perhaps email it, the link to her, or I don't know why people sometimes can't get in.
I'll repost it and
yeah, maybe email.
Yeah.
Shall I just email it to her quickly? Okay. Right.
I think part of the problem might be that I had to kind of get rid of some words to get in, like the meeting. It was all joined. So if you email it, it might.
Yeah, I think because I copy and pasted it from Signal,
yes,
may have been the problem. Okay, I'll just copy the invite link directly. Copy invitation. I'll do that. Hopefully that will work. Okay, I think we'll just start actually. So I think we'll just start. Sorry, I'm just sorting out a few boxes on my computer that are kind of. Okay, so very warm welcome to Sarah Dodd, who is from Tree Law. And we met Sarah, Joe and I met her at the Tree Action Design Group's insurance and trees it was called a workshop. It was kind of a seminar with lots of different talkers a few weeks ago. And it was really interesting. And I was really interested to hear about Sarah and what she does, and from sort of getting the other view and how it might, for us as a tree group, how we could sort of almost, you know, pick her brain about what's currently happening and her knowledge and expertise, and how she might advise us as well, like what parts of law are being used and how could we maybe lobby for the law to be changed, or, you know, but I'm sure I've got specific questions to ask, but hopefully we can kind of, you know, get most of those covered. If you've got any questions you'd like to ask Sarah. And I was really interested because I was looking at your website, Sarah, and you are a tree hugger and you've got a lovely picture of yourself hugging a tree. So it'd be really nice to hear a bit more about you and your story and your love of trees, perhaps to start with, you know, just briefly, we're the Haringey Tree Protectors. We were set up a couple of years ago during lockdown. And we've been involved in various campaigns to try to protect and preserve mature trees in Haringey that we see as under increasing threat from, you know, insurers, developers, you know, councils, you know, all kinds of different threats to trees. So we're a group of residents. Some of us are in environmental groups like XR as well, but a real mixed bag of a group. Lots of people joining now. That's great. Okay. And we're really, really passionate about trees, as you seem to be. So yeah, I'll hand it over to you if you wanted to just kind of tell us a bit about you, and then we can kind of have quite a freewheeling kind of discussion with questions, if that's okay.
Yeah, of course. Yeah. Thanks, Gio. And hi, everybody. Really nice to meet you all on screen. I think I've met Glenys, so hi to you again, Glenys. Hi. It's a bit of a background about me. So I'm a solicitor. I've been a solicitor for about 21 years. I think my qualification had its 21st birthday in January, which made me feel very old. But for about 19-20 years, I worked for corporate law firms working for insurance companies, and I was dealing with lots of sorts of cases involving damage to property, whether that was caused by trees or other things such as floods or fires or impact claims. But then later on in my career, I specialized very much in tree claims. And as I was working, it was just becoming less and less palatable to me. Or I felt there was a huge contradiction in my mind with how the claims are being dealt with and climate change. And I just thought, well, there needs to be some change here, because we can't sort of keep going in this quite sort of traditional approach. But I didn't feel that the role that I was in a traditional law firm could bring about that level of change. So probably naively, with perhaps a little bit of blissful ignorance and a little bit too overconfident, I thought I'd set up my own firm to see if I could make some change in that respect. So I set Tree Law up. It launched on the 1st of November 21. It's quite hard work setting up a law firm, so that was a good 6-month project to even open the doors on day one. And the whole ethos of the business is to try and deal with claims involving trees, but in as environmentally friendly a way as possible. I can't ever think of a way to encapsulate it really quickly other than to sort of saying in like that environmentally friendly way. And through trying to describe my business to people, I almost branded myself the tree hugging lawyer, because it was a very quick way to put across to people what the values of me and the business are. So yeah, so that's me in a nutshell, really. So yeah.
Yeah, can I just ask, what did you feel, having worked in kind of a conventional law firm, what sort of made you uneasy or uncomfortable, or increasingly feeling like you didn't fit in terms of the way they were dealing with, you know, insurance claims against trees? Is that what were you seeing? Trees kind of just being felled as a default rather than an actual, I mean, what were you seeing?
Well, I suppose a lot of it is, you know, I was seeing that change was needed, and obviously trying to bring about change when you're working in a huge law firm is just like trying to turn a cruise ship. You know, it's very difficult to do. It's not small enough and agile enough to do. But yeah, you're right. I mean, as a lawyer working for big insurance companies, you know, the default position is, and I suppose the process tends to be that if there is a claim, and I'm talking about subsidence claims here typically, so if there's a claim where a tree is suspected to be the cause of the damage, almost step one in the quite tried and tested process, which is really typical across all the insurance companies, is to basically try and get work done to that tree, whether that is tree removal or tree reduction, because that is sort of step one in eliminating a possible cause of the damage to the property. Now, you know, that's a huge generalization. There are obviously some cases in which that doesn't happen, but that tends to be the approach, because these are very much dealt with on a volume basis, so that, you know, there are thousands of these going through year after year after year. So that tends to be the journey that a claim will go on. You know, step one, has the property suffered from subsidence damage? Yes. Are there trees nearby? Is it on a clay soil? Yes. It could be those trees. Let's just try and get some work to those trees done if they're a potential cause, because that could solve the problem.
And because I was quite interested when I, as I understood it, because I'm a lay person who's learning about all this stuff, so I'm not a lawyer and I'm not an arboriculturalist, you know, but as far as I understood it, which I was quite interested that you said something slightly different, that I thought, I can't speak for the whole group, but that a tree only has to be shown to have been making a contribution, however small, to the whole picture, to justify felling it. But you said that you seem to suggest that it actually has to be shown to be the direct cause, or perhaps I misunderstood it.
No, I think both of those are probably right, Gio. So there are almost two stages of a legal claim. So the stage where a local authority will be in receipt of, you know, I'm presuming now a local authority tree as well. Sorry, the situation I'm presuming is a home is damaged, and it's damaged by what they're alleging, you know, a local authority street tree. So that's the situation that I'm presuming I'm talking about here. So there are two stages. The first stage is what's called the mitigation stage. So that is when site investigations are carried out. Now that could be detailed with a load of, you know, root IDs, soil IDs, arboriculture report, monitoring. You could have all that evidence, or it could have very little evidence. But, you know, however much evidence there is, that's given to the local authority, and the local authority are asked to carry out tree works. Now in that mitigation phase, I think you're right, Gio, your comment's right, which is if the tree is thought to be a causative factor, really almost like no matter how big a cause, because it could be one of a variety of causes, because often, you know, these things tend not to be one-dimensional. Could be one tree, could be lots of trees acting all at once, could also be some leak in drains, you know, there could be some other issues as well going on. If it is a causative factor in that mitigation phase of the claim, yes, the tree owner will be asked, is likely to be asked to carry out some work. The point that I was making, which is a little bit confusing perhaps, is that's in the litigation side of the claim. So when it actually becomes a legal case, and again, it's as with any sort of point on law, you can argue both sides. But when it gets into asking for money damages, so in the legal side of the case, the tree has got to be found to be like the primary cause of the damage in order for the tree owner to be liable for any money damages.
Right.
That's good. That's really helpful. Thank you.
Again, some would argue that that wasn't right, but I think there's more case law which supports that than there is supporting something else.
Yeah.
Because often it crops up when you'll have more than one tree involved, and often it's like more than one tree in different ownership. So you may have a neighbour owns one tree, the council owns one tree, and the actual homeowner owns one tree. And you know, you may look at it and say, well, we're all like 33.3% responsible if there's 3 trees. But it's not quite as simple as that. It tends to be that the legal blame can only fall on the shoulders of the person responsible for the primary cause.
Right.
So,
yeah, would other people like to come in and ask questions?
I'd like a question.
Yeah. Right.
So Sarah, how long have you been running this tree law?
Since 1st of November 21, so about 1.5 years now.
Okay, and have you made a difference? Do you feel that you've been able to save trees that other lawyers might not have done?
Oh, that's a good question.
Well, presumably that's your intention.
Oh yeah, it is. And one of the liberating things I've been able to do, and which I never would have been able to do previously, is I've worked for a couple of campaign groups, and I recommended one campaign group get Extinction Rebellion involved because they needed to act really quickly with maximum disruption. I would never have been able to enter. I would have been disciplined probably for doing that in a corporate role. It would have been too political. But yeah, so I was unfortunately in that situation. That didn't make a difference. That tree still came down. That was in where was it? In Peterborough. So that was very sad. But as I said, you know, but as I'm saying to, and this is perhaps going off on a tangent, but as I'm saying to these campaign groups, and I am talking to a couple of them, that where they may be failing in the claims that perhaps I'm dealing with them. So that Peterborough one, that it was an ancient oak, and that ended up coming down very, very sadly, even though, you know, we did as much as we could to try and avoid it coming down. What I've said to them is, what you've done is you've created an important stepping stone for those people who come after you, who are going to benefit from your experience and what you've done. So, you know, although it was totally crushing, don't feel that has been for nothing.
Was the Peterborough case one where there's been an extension on very flimsy foundations?
Yes,
and it was the remaining tree in what had been a whole sort of road full of beautiful old trees.
Yes, it was like it was almost a footpath behind some relatively modern-ish houses.
Yeah.
And there was an oak tree in the garden of the property that was damaged, and an oak tree on the other side of the fence still in the ownership of the council. The oak tree in the garden got felled because the TPO got removed. And then it was sort of a leftover piece about, oh, we did ask the council to fell the other oak tree, but we actually didn't know whether that was needed in the end, because they'd already felled one tree, which was closer, and probably if there was a cause, it was the cause, and it was sad enough that went. But then the council felt too concerned that they faced a potential liability if the tree wasn't removed, and then they were concerned about the tree going on to impact other properties nearby that weren't yet damaged but might be damaged in the future. And we got a root barrier quote, you know, we got a root barrier design spec'd up for them to try and make them comfortable about that, but they weren't comfortable with that. We tried to talk to them about the soil underneath the properties, because actually the soil wasn't clay at all and it didn't have any shrinkability, so really we didn't think that the trees had ever been a cause. And also it didn't seem to be, the house insurer didn't ever seem to be re-asked, oh, do you still want us to do this? Is the property still moving? It was just it was a very bizarre.
May I ask who was the insurer in that case?
I don't know who the insurer was in that case. They managed to not manage, but you know, their name didn't come forward.
Right. And there's no way of claiming against the builder who didn't put in adequate foundations for the extension.
I think enough time had passed, because in law you have a limitation period. So basically, unless you start a legal claim within 6 years of something happening, you've run out of time. Now there's some exceptions to that, you know, but that's largely the rule. I think it had been there far longer than 6 years. Yeah, and that throws up other issues as well. This shallow foundations can be a tricky issue to defend a claim on. So when I'm talking about the claim, remember I'm splitting it in 2 halves. So I'm not talking about the bit when the tree owner has been asked to do reduction or removal of a tree. I'm talking about the legal claim at the end, when regardless of what's happened to the tree, the tree owner's been asked for money damages. And in that situation, that is a claim in nuisance and negligence, and the law of nuisance and negligence is well established. You know, it's been established law for, oh gosh, you know, 100 years or so. I can't remember when the case law for that starts. But there's a theory called the eggshell skull theory, which comes from a personal injury case where I think somebody had their head hit, and because they had a particularly thin skull, they had a very severe brain injury, whereas an ordinary person would have probably been fine. And that translates into these cases where there's shallow foundations. So it can be very difficult for a tree owning defendant to say, well, we shouldn't be responsible because the foundations were shallow, because the law sort of says, well, you know, that's tough luck. You sort of take the house as you find it. You know, particularly in London, where there'll be old properties and lots of properties with shallow foundations, the local authorities know that. They know that the foundations are shallow. There's an awful lot of law around that. So yeah, there's a lot more I could say about that.
Yeah, I'm just going to take a question from Joe, and then I'm going to come in again with something else.
Okay, thanks. No, I mean, I have lots of questions, but I'll just stick to 1 or 2 quick ones. In terms of that shallow foundations stuff, one thing that Shift and Glennis's group has, one of the ideas they've had is that if a tree is older than a building, if a tree is already mature when a building is built, then the builders of that building should be taking into consideration the proximity of the tree in terms of the foundations that they build. And if they don't, then they should be liable for the repair, because if you see there's a mature tree there, then you should take that into consideration when you're constructing the building. It's just how you, just wondering what you thought of that concept, and if that's possible to turn that into some kind of legislation. The other thing I just wanted to clarify as well, though, going back to what you were saying originally, about the difference between mitigation and litigation. But with the litigation, that is the kind of leverage that the insurers use on, like, the council, for instance, that you will become liable for the cost of this repair. We will become litigious or whatever,
Mhm.
if you don't mitigate it either through reducing or removing the tree. And
Mhm.
it sounded like, if I understood correctly, in the litigation side of things, to be successful, you have to prove that the tree is the primary cause of
Mhm.
subsidence.
Yeah.
And so I think we can kind of use that, because then that it has to be proved that that is the main cause of
Mhm.
subsidence. But I think at the moment it's just accepted by councils that the insurers can say you will become liable, but unless they can prove that the tree is the primary cause of subsidence, their case for litigation will not be successful theoretically.
Mm.
Have I understood that correctly?
Yes, that's correct, Joe. That's really well put.
Because I think that's an argument that we can then go to the council, who are saying we're going to come up with this bill, and we can say, well, you're only going to be liable for that bill if it is proved that that tree is the primary cause of subsidence. And if there's other factors, they need to be taken into consideration, or you won't become liable.
Yeah, and it's not just cause which determines whether the council will be liable either. So in negligence, there are 3 stages that a claimant will have to succeed at in order to be able to be awarded damages at the end, and cause is only one of them. And actually there are there's one other key one that is a good one for local authority tree owners to argue. So the first one is, did the local authority owe a duty of care? Well, yes. I mean, that if they're the tree owners and manage to speak trees, yes, they do owe their neighbours a duty of care. Then the next one is, was the damage foreseeable to the local authority? Now, there's an awful lot of case law on foreseeability. What the law says is, for a defendant to be liable for money, the defendant had to have been able to foresee the risk of that particular tree causing damage to that particular property before that damage actually occurred. And actually, they should have taken steps to avoid it from happening. Often that can be difficult to prove. There was some case law which came out around 10 years ago. It was around 2012. So before that case law, you used to just be able to tick the foreseeability box and say, look, all local authorities know that trees might cause damage to properties. But that really changed in 2012 when there was a case called Berent, I'll check which local authority that was against. I got my little case law booklet here. It's a London local authority, but I'm not gonna be able to remember which one it was. That said that, yeah, for a local authority to be liable, they had to have been aware of the risk of the particular tree causing damage to the particular property before that damage actually happened. But these points, so saying to a local authority, right, you've been asked by whoever to remove your tree, but what we're saying to you is, feel comfortable about pushing back, because if you say no and they go on and do expensive work to the property and then give you a bill for 100 grand for underpinning, we don't think you're likely to be liable for that, because you're going to be able to argue on foreseeability and causation. That although that's right, that can be pretty hard to get a local authority comfortable with that, because even if they could argue the defence of a case on those points, that doesn't mean that they won't face litigation. Sides will argue black is white, so you may have a claimant running a case all the way to trial saying it was foreseeable to the local authority and the tree was the main cause. So they would still have to spend a lot of money to defend it, even though their defence might be strong.
And sorry to just butt in, haven't the insurance companies established and won enough cases on the books to kind of make it quite because what we understood was, since the kind of 70s, when insurers first started moving in with their lawyers on trees and subsidence.
Yeah.
Correct me if I'm wrong, but it's become much worse since those early droughts, those intense droughts. But haven't they established enough with their sort of might and their expensive lawyers, haven't they established enough cases that local authorities are just fearful to go to court, even if they could probably argue the foreseeability and the cause, duty of care, whatever, those points. But they're just so afraid to even go there. They're advised by their legal teams. Like, I know Mike Carter, our deputy leader of the council, at one point said in a conversation, like, they just won't let us go to court. And because what we need is some cases on the books where trees win, you know, or they see. But he said that there's so much fear and trepidation around actually, you know, pushing back and taking
I think even if whether you're a claimant or a defendant, even if you win a case, you will be out of pocket financially, because even though, you know, the council is a defendant, even though if they won in the defense of a claim, not only would they not have to pay any legal damages, but they'd get their legal costs reimbursed. It's never 100%. You know, they may get 70% of their costs reimbursed. If they went to a trial, their cost bill, you know, they would incur 100 grand of costs easily. That's probably quite a conservative estimate. So if they're only getting 70% of those back, they're 30 grand down, even though they've won. And that's the risk of litigation. And it can almost be a case of who, you know, it feels like a game of chicken at times, you know, who's got the money to be able to see it through. You know, who's willing to take that, who's willing to run that risk.
This is why we want to change the law. So do other people want to come in with some questions or just observations or anything at all? Glenys?
Well, it's probably not a very good question, but do you think insurers are all the same, or are some more likely to go after trees than others? I mean, one thing that we could be doing as Shift is recommending that homeowners use one insurer rather than another. Is there any difference?
That's a good question again, Glenys. Obviously the insurers have got different sorts of climate related policies that they'll have put out to the public. So that'll be different there. But what I would say is a lot of these insurers, these claims almost get run by their suppliers. So you'll have come across probably the likes of Crawford's and Innovation Group, and there's the sort of like loss adjuster claims handlers. So it's almost like if you want to see a difference in how they're being dealt with, you need to look at both the insurer and their claims handlers. You know, speaking truthfully, I couldn't say that I could list one that sort of, you know, one or more that are sort of more not environmentally friendly, that's the wrong expression, but deal with these claims in a different way. But there are some out there that are really trying to change the way that these claims are dealt with, and not just these, you know, other insurance perils as well that are climate related, like flooding and stuff like that, and burst pipes. You know, they are trying to deal with them differently.
Could I just ask, which parts of the law are being used against trees at the moment in the whole insurance and subsidence? Like, if you could point to the, you know, which parts of the legislation do they typically use, or does it not work like that? Is it? So
these cases are run in the civil law of tort, so in nuisance and negligence. Occasionally the Highways Act might come into play, but they're largely nuisance and negligence cases, which means that you find the law by reading back through previous cases. That's why I'm sat here with my subsidence sort of case law booklet, because it's the history of the previous cases that really tell you what the law is. Now, it's interesting what you said, Gia, which is, you know, we need some more cases, and you know, you're right, we do need some more cases, because we need we need some modern cases. We need a judge to be listening to evidence with a very climate focused view. And my thought is, when some tree root subsidence cases start hitting the court now, the court aren't going to be able to avoid looking at it with a climate slant on. But then I wonder whether I'm just living in, you know, a bit of my own echo chamber, and I'm thinking, well, of course a judge is going to consider climates, because it'd be absolutely ridiculous not to. But I don't know until that happens.
We did have one judge in our local hearing case. We were quite surprised that the first judge, well, the judge that, I mean, ultimately he did award them their injunction, didn't he? Is that, yeah? But I think in the process of doing it and his summing up, he did show at least an awareness of trees, ecology, the climate crisis, which was quite interesting, because we didn't expect that. I mean, you know, but it's still such small steps, you know, and most judges we found, I don't know. Joe, do you want to come in? Because I know.
Just, yeah, following on from that, the judge in that case where the council were applying for their injunction and we challenged the injunction, and a lot of the case for Oakville Road was sort of hinging on this ombudsman's report. There had been an ombudsman's report in 2017 on this case, which said that basically the foundations should be the solution. There should be an engineering solution.
Yeah. And
because of what happened, the house owners in one of the houses applied for another ombudsman's ruling, which has been in process and still hasn't come out yet. But the judge in the hearing that we had in December basically said he adjourned it because he said that we should wait to make a decision until the ombudsman's ruling had come out. So he was basically supporting what we had said. It didn't ultimately end that way for us, but we were quite surprised when he kind of saw the logic and the reason of that, because I certainly wasn't expecting him take that position.
Yeah, I think some, but it is surprising to, like you were talking about an echo chamber, just with my brief encounters with the law in terms of like judges and stuff, you do find that they're operating in this system that it's not really, the urgency of the crisis is not really filtering up. You know, it feels like it's very much business as usual. I mean, how would you advise us if we wanted to change? Is the only way really, other than a change in statutes, is the only other way through the tort law process to try to get some cases into the courts that actually win? But I suppose that would involve councils who are willing to take the risk and be brave rather than capitulate. Is that really the only other way, other than a change from central government on the law books, like, you know, in the parliament?
Yeah, I mean, there's lots of things going on. So yeah, you're right. A way to immediately impact the law of nuisance and negligence is to get a judge and a judgment which sets out something in your favour, which talks about the environment, and it, you know, creates that really useful precedent. And, you know, that could happen. There could be one that's in court at the moment that we don't know about, and, you know, a judgment's going to land in the next month. And the good thing about it, as soon as it lands, it's immediately relevant. You know, you don't have to wait for it to be enacted. It's immediately relevant. Obviously, the more senior court it's in, the better. If you've got it in just, you know, the county court or the high court, that's persuasive, but it's not binding. But then the minute it goes to the Court of Appeal or something before the Supreme Court, you know, the further up it gets, the more binding it is. So everyone's got to follow it. But I don't know whether one of those is going ahead at the moment. And you're right, they're expensive. Insurers, you know, neither party wants to spend money on litigation. So what's encouraged nowadays is mediation, which is like a roundtable meeting where these sorts of cases are discussed and a settlement is reached, which avoids the need to go to a trial, saves money, saves costs, saves time. And mediations are brilliant. And actually mediations are quite climate friendly because they speed things up, and obviously they don't take as long, so they're not as sort of energy and people intensive. But the downside of them is they're secret. You never know what happens at them, and they create no binding precedent. So that means a load of these cases which may have gone to litigation before a judge and created a precedent judgment are getting settled at mediation, which is a good thing. I'm really in favour of mediation, but it does stop those new cases coming forward. But aside from that, we've got quite a bit of political stuff going on, because trees are really high up on the agenda of the government. With the England Trees Action Plan, etc. And I'm on the Joint Mitigation Protocol Committee of the London Tree Officers Association, which is to try and put in place a protocol for both the insurance side and the local authority side to work together about these cases. What that doesn't do is, what you guys would be looking for, I expect, would be a situation where it's a protocol basically, which is there's an agreed level of evidence that has to be provided before the local authority will even consider taking any action with the trees, which I suppose, Joe, comes back to what you were saying. It's basically saying we're in the mitigation phase, but what you have to do is provide us with some really concrete, persuasive evidence that the tree is the primary cause before we'll even consider touching it. Gone are the days when you'll be able to just send us an arboriculture report and say, take the tree down. And that is getting government support, that joint mitigation protocol, but that's going on at the moment. Actually, I think it was talked about in Parliament in the last week or so.
Susie.
Yeah, Catherine West mentioned it.
Yeah. Catherine West spoke about it.
Yeah.
Susie, do you want to come in here?
Yeah, I was just going to check I will get that down clearly. It's the Joint Mitigation Protocol of London Tree Officers.
That's right. Yeah.
Is there any more to? Have you got that in a sort of? Is there a piece of information
just to say
online? We can.
If you looked at the London Tree Officers Association website, you'll see the old version of it there online, but it's in the process of being
It was just if people wanted a link. Thank you.
Just sorry to jump in. We do know about
come in.
Yeah, go on, Jane. Jane said I had it for ages.
Yeah, sorry, I didn't see.
Right. I've just had a real setback about plastic today, about how to get your head around what's doing plastic, and basically the only answer to that is to stop producing plastic. There is no way that we are going to fight this in any meaningful way until we do that. And it seems to me that we're not what we need to do is go much further back, because what we're doing is hitting things when there's already a problem. And what we need to do is develop a strategy which reduces the problem and reduces the conflict, so that for planning and developers and have to honor the tree that's already there, and not put forward something that is going to conflict with that and undermine, bring the tree down eventually. So we I think the law we as activists have to also think outside the box, outside this legal framework.
And I think
I think it would be really good to actually pursue that and try and build something up which would change the way we act at the moment.
Yeah, I mean, this is our bigger aim as a group. Is the bigger picture is really the change in the law, and I totally agree. We need a whole change in the structure and the way trees are. You mean
we need the councils to stop, we need to negotiate with we need to win the councils over so that they are not automatically doing things and allowing things to happen, which are going to result in trees getting cut down.
Well, that's what I was thinking about, Jane. I mean, education is the answer to most things, isn't it? And if we can get this sort of message across about the importance of saving trees, get the message across, first of all, to homeowners to say, okay, if your house is falling down, yes, you've got to make a correct claim. But if you've got a tiny crack, just hold off a bit, you know. The other bit of education would be, I think, trying to get the council's lawyers to change their attitude and to understand the importance of trees, because as Sarah said, we might all be operating within our own little echo chamber thinking the environment's very important, but some of those guys that have been doing that job for a hell of a long time aren't up to date with things. They you know, they've got blinkers on. They don't necessarily know what's going on. So I think some sort of education process should be used. And I think, Gio, I mean, education is one of the things we've tried to work on as well, isn't it? You know, when we've had our local meetings, we've tried to get that message across to hundreds of local residents, live with the idea of subsidence. Cracks come and go. You know, this is something we have to put up with. Victorians used to. We shouldn't be so fussy about a tiny little crack.
And that's an interesting point that you raised, Glenn, because something that's been discussed over, you know, it sort of comes in and out of fashion, I suppose, is around creating a building passport, so that as a homeowner, it's really hammered home to you that, you know, like you MOT and service your car, and that's your responsibility, that you have that same responsibility with your house. And the minute you see a crack, your default position shouldn't necessarily be let's make an insurance claim. It should be to, you know, do some minor repair, you know, do some minor upkeep works yourself.
And you know, a lot of people, they make these claims about subsidence when they're trying to buy or sell a house. And the idea that they might paper over the cracks seems like, well, you know, that's a bad thing to do. It's almost sort of the shorthand for doing the wrong thing.
Yeah.
But actually, it's probably the right thing to do if you want to sell your house.
And I think it's fine to do. I've been involved in a claim involving somebody papering over the cracks, and that turned into a claim in fraudulent misrepresentation. But that was only because they papered over the cracks and kept it secret. You know, when they were asked the direct question, has there ever been any cracking or any damage? And they said no, that's a problem. But, you know, if you've got minor cracking, the British, the BRE, I think is the British Research Establishment, has got grades of cracking from 1 up to 5, 6. You know, 1 is when you're dealing with 0 and 1, you know, that's hairline cracking. That's just in the, you know, the course of home maintenance. You know, all of our homes move up and down with the seasons. And they are within a really acceptable range. It's only really when it starts hitting category 2 and upwards that it should really be forming any part of a
and is that how insurers respond? If a homeowner makes a claim and the crack is category 1, for example, presumably that's the smallest one, do they say, well, don't worry about it?
I can't answer that. I can't say yes or no. I think some may do, some may not.
Yeah, I think the system is it's supporting that. I mean, it comes down to kind of money, and property is more important than, you know, nature, and we want to I want to turn it so it's less on the tree and more on the house. You know, what can we do to shore up our houses? But the thing is, the council in interactions always say we're bound by law. So as well as education, I totally agree, as well as educating people about like not getting so paranoid about cracks in their houses, it's also educating people about the wonder and amazing, incredible, like how trees are basically saving us and can save us, and like live with, but also getting that change in statute, getting tighter protections for trees. And I wanted to ask your view on our wider aim is to try and start lobbying for change, you know, with Catherine West, if we can get her on board. And I know it takes ages, you have to table a motion, and it could take years to creep through, and you have to work on lots of documents and try and get a national campaign going. But to get a change in the law, I mean, you know, you know, how would we go about doing that, and who should we be lobbying? Do you know?
I don't know if you want to go for an absolute standing start. I don't know, but we've got the Environment Act, which, you know, that started in before 2018, and it was for the purpose of you know, helping a couple of these key issues, and that went live in November 21, just after COP26, and we're waiting for those key bits that are going to be helpful here to actually be enacted, because they're there in the statute but they're not enacted yet. So the two key things that are going to help from the Environment Act are the duty to consult, which is when the local authority wants to remove a street tree, it's no longer just the local authority and the insurance industry speaking to one another. The local authority have got to stick a notice on the tree and actually put it out to residents to be able to raise any issues they've got about that tree removal. So they've got to consult with residents. That hasn't launched yet. I know some local authorities are starting to do it, but it hasn't launched yet. We're waiting for DEFRA to give some guidance on that process and what it's going to look like, but that's being very slow. They're saying now, hopefully by the autumn. So there's that new protection coming out. And then the other one is the biodiversity net gain. So going to what you were saying, Jane, you know, what are we going to do safeguard things into the future? So there is stuff that's happening. So we've got, you know, the NHBC, the sort of guarantee provider for new build houses, the National House Builders Consortium, or I'm not sure what it's called. So they've got some guidance specifically around foundation depths when building near trees. So if you Googled NHBC building near trees, you would see, I think it's chapter 4.2 it's called, it's their guidance on foundation depths and building near trees. Now, in collaboration with the Environment Act, the England Trees Action Plan, the Biodiversity Net Gain, with all of this happening at the same time, the NHBC are revising that guidance and working with the government to produce revised guidance. So you're really hoping that any properties built from this point on will really be limiting that risk of damage, because it will really flag up the need to take into account the trees in the area when those properties are built. And then also sorry, Jane, go on.
Well, I was just saying that, you know, it hasn't been enacted yet, but it will be enacted. It's just, is this just a process? I mean, could we not talk to the council about being ahead of the game on that? Yeah, this will be law. Why aren't you getting your head around it now?
Yeah, you could do. The thing is getting their head around it. They don't know what they're getting their head around, because the guidance from DEFRA telling them what they have to do isn't out yet. Okay. They know that at some point in the future they're going to need to consult with residents when they want to remove one of their own trees, if it's a healthy tree. Obviously, if it's dead and dying or dangerous, they don't need to consult, because that needs to be taken down. You know, that might need to be taken down for health and safety.
Yeah, this is what I'm worried about, these exemptions, because they often say that a tree is dead, diseased, or dying, and I think it's used as an excuse, because many trees have disease in them now, and they're so worried about litigation from if a branch falls off a tree. They're so paranoid about it. I think sometimes they're taking trees down because it might fall, or it might, you know. And the thing is, there's no obligation for them to show arbor reports showing, well, can you show us what the arboriculturalists, you know, where are the reports on the disease? This has happened recently. A few cases where on street trees were felled because they were diseased. So I said to the people, can you ask to see the reports from the arboriculturalist or the tree officer that, you know, gives us that evidence? And that's the thing, it's a lack of evidence in many cases. There's a lack of transparency, and I'm worried that councils may use that to wriggle round to fell trees. I mean, how does the insurance, there's no guidance for the insurance claims, like how this public duty to consult when it's an insurance claim, how is that going to interact with that new bit of legislation?
I mean, that almost doesn't affect the insurance company. So, you know, that's for the the only way it will affect the insurance company is it will probably cause a delay in getting a response from the local authority, because the local authority will have to go through those additional steps. And it might create a situation whereby the local authority decide not to do some work because of those objections. So that would change the situation for the insurer. But it's not for the insurer, it's not going to create any additional steps or in the insurance company's process.
But we're going to see an increase in claims. Apparently last summer I read in 2 separate sort of reports, cases have gone up 200, and then another report said 400%. Like, you're the chair of the subsidence forum as well. I know.
I've just stepped down. I stepped down in the last month, but yeah.
I just wonder whether, with your ear to the ground from the insurance or subsidence industry, like, what are they saying? Are they worried about these new slight sort of curbs on their I don't know what's the kind of word on the insurance and subsidence kind of from their point of, are they worried? Are they worried that they won't be able to avoid paying out like they're doing basically most of the time for trees,
What I would say is in the last 6 to 12 months, I've definitely seen a marked change in insurers and then wanting to have open conversations with the local authorities to understand each other's positions, because the positions of the insurance companies and the positions of the local authorities have been quite entrenched, with them not really fully appreciating the pressures that each other might be under, and then misconstruing how certain things are done, misunderstanding pressures, making assumptions, and it creates quite a polarized situation. But in the last sort of 6 to 12 months, there is massive change in wanting to get together and have conversations. I think it's because insurers, as well as anyone else, realize that they need to work together to find a sort of a palatable solution or way forward going into the future. Insurers are aware of the fact that if all street trees are removed because they're at risk of causing damage, well, let's just remove them all because that's just a pain in the neck. Insurers are aware of the fact that that's just going to cause them other problems. They're going to have flooding cases, they're going to have wildfires, that it just changes it to a different risk. They are aware of that.
Well, that's what they're trying. Yeah, I mean, has that been put on the? Sometimes I think that if you take their kind of rationale to its end point, you will see all mature trees felled, because they might become insurance claims. And this is my fear, that it's just the numbers are going to rise and rise and rise. So the insurance industry, I mean, I'd like to see trees left out of claims completely, that's the ideal for me, unless it's really, really like indisputable that a tree is about to fall on a house. But for me, that's the bottom line for me. I don't know how other people feel, but do other people want to come in? Like Katie, do you have anything
Hi, it got so interesting. Thank you, Sarah. It's so interesting listening to it. I was eating my tea earlier, so I didn't want but yeah, I just thought just something you were saying earlier. I thought we need precedents. To move things along, you need legal precedents. And I was kind of wondering, if you pick the right tree, if we're talking about maybe 30 grand that the council just don't want to be stuck with paying, if there could be like a massive campaign and a crowdfunding campaign to sort of get the council on side, a council who's kind of like veering in that direction anyway, and say, look, we've raised this money, here it is, here's the pot. And obviously it'd have to be a massive campaign but it'd have to be the right tree, the right celebrity tree. And what it does as well is it says to people, look, this is how people feel about trees. you know, they're willing to kind of go this far, and for this particular, you know, mature tree. So it could do two things. It could set precedents, and if it was very carefully planned, where you did it in a few cities at the same time or something, and also it just escalates that whole thing. Oh yeah, trees, Sheffield, look, they they decided to knock them all down. Isn't that crazy? But people were just walking around while it was happening, you know.
Yeah, but even if it was, you know, when I open a new case, obviously one of the first things I do is, you know, I put in my file, my case management file, you know, what type of tree it is, because even if you think, right, well, let's just start with the oak trees, you know, because that would, you know, when you've got an oak that is being asked to be removed because it's causing damage to a conservatory. I mean, like, my thought, you know, my personal feeling is that, you know, that is the prime example of the sort of case that shouldn't be anywhere near asking for that tree to be removed. I mean, that's crazy. And there's things that, you've heard of caveat valuations, have you, for being able to put a financial value on the tree? And you know, there's a lot of work, a lot of things are happening all at once here. So caveat has been in existence since 2008, I think, as a valuation system, and it's just been tweaked a little bit. So a way of putting a financial value on trees. So to be able to say, well, you know, that tree's had its caveat value done and it's worth 250 grand. And then there's damage to the conservatory, which actually, if we just pulled the conservatory off and rebuilt another one on proper foundations, would cost 40 grand. I mean, it's just, I mean, and then that's like 250 versus 40. Well, we should just stomach the 40 and save the 250. You know, that, and I know that's incredibly one-dimensional caveat, because it's not valuing the tree for all of its ecosystem services, but there's loads of work being done on trying to more appropriately value trees. So there's work done by a company called Treeconomics, and they have an iTree valuation system, which has been worked on by Leicester City Council to try and input all brilliant things such as the financial value of the tree for the effect that it has on people's health and well-being. So you know when they say that if you're in hospital and you can see a tree out of your window, you get better. However, you know they're trying to put money figures on those sorts of things as well. So it's not just seeing a tree as a carbon store, which obviously is an important part of it, but it's seeing it holistically and trying to say, well, if you chop that down to replace all of that you've lost, it's not just the carbon. You know, you've got to put a flood scheme in place, you've got to be removing pollution from the air, you've got to be creating shades so people can still live there in the hot summer months. You know, you've got to be, it's increased impact on the NHS. You've got, people are more likely, you know, there's something called green equity, and people are more likely to be unemployed if they live in an area where they can't see a tree. You know, it's stuff like that.
Yeah, they do quantify it. They have quantified it in terms of health recovery. That's, yeah.
They're doing
the other thing is, sorry, go on.
Sorry, they're doing that with the oak tree that was felled in the Holtree oak. They're trying to go down a health, like, obviously it's retrospective, but I should just say, Sarah, that Katie made the Happy Man tree film. It's a great environmental film, and she was really involved with that campaign. Oh, yeah. So it was an amazing campaign. Just you should try and see it if you can.
Where can I find it? Is it on YouTube?
Not yet, no, but it will be after October. But we had a screening last week.
Oh, wow. Congratulations.
I wanted to say that their campaign was incredible, and they did all the right things. They got even an architect to design a really credible new design. It was a stunning tree of the year by the Woodland Trust. It was an enormous sycamore, really about, was it 200 years old?
And it was 1870, so 150.
And it was a key, and this is the thing, because it was such a key, amazing tree, and yet still it was felled by the developers, and it's a tragedy. And so, you know, like Katie was saying, we need to get some cases that actually Yeah, Katie, sorry, I interrupted. Carry on with your
No, no.
bit.
No, I just thought it's interesting you were saying about kind of bringing the whole, you know, putting notices on trees where there's an intention, you know, to, you know, but then I think when that happens, all those reports need to be in the public domain.
See that, and that's why we're waiting for the guidance, Katie, because there's loads of stuff on what, you know, how do you put that in the public domain whilst respecting GDPR? I think there's a bit of that going on in the background. Yeah, something else cropped up in my mind that I was going to say. What? There's somebody I follow on LinkedIn, and he's done a talk to the Arboricultural Association, and he's based over in the Netherlands, and he's set up something recently, which actually I'll see if I can find it and I'll share with you. But it's about.
Oh, your audio's gone. Your audio's gone off, Sarah.
Sorry, I accidentally muted myself. Hang on. I'm probably not going to be able to find it now while I'm on here, but I'll share it with you when we get off the call. But he spoke to the Arboricultural Association actually on a session which is on YouTube, and it's a really useful session to watch. So I'll see if I can find it.
Sarah, just wanted to say, Haringey repeatedly seemed to refuse. To sign up for the joint mitigation protocol. Joe tried to get them to, you know, we've tried to nudge them quite a few times. Do you know why they might not want to do that? Do you have any idea? I think they spoke about their insurers, Plexus, being involved in that decision.
Plexus are solicitors.
Oh, are they? But they sort of said, oh, we don't need to. Plexus sort of, I can't remember the details of it, but they just seem to be, they don't seem to want to do it. And Joe, do you want to come in?
Well, that was kind of one of the things I was going to ask about was in relation to the joint mitigation protocol.
Yeah.
Which is, you know, an attempt to kind of create a system that's potentially national.
Yeah.
Between the insurance industry and local authorities, because at the moment it seems like the engineering reports are all paid for by the insurers, who have an interest in the decision going against the tree, in that it will be, if they remove the tree, then they can move away from the case and potentially not pay for engineering solutions to the building.
Yeah.
And I was just wondering, well, one thing we were thinking about with Shift as well was like having a kind of national independent monitoring process, of which the JMP seems to be sort of working towards somehow. But like Haringey looked at the JMP in 2008 for their tree action plan. They again looked at it again in their more recent plan. And as Gio says, they've decided not to sign up to the JMP on the advice of their legal Plexus. They are doing some of the monitoring things themselves, but you know, just, I mean, in terms of changing law, but also working towards trying to create a national monitoring system, subsidence claim, so it's across the country and everyone knows you know what the requirements are. And the financial ombudsman's page on subsidence is quite comprehensive about, if it goes to the ombudsman, what you are meant to have done to kind of prove that the tree is a cause of subsidence. So anyway, yeah, it's just a bit of frustration with it not being that those reports are kind of paid for by the insurers rather than an independent body, or not being able to, because we did request for the Oakfield Road tree to see the engineering report so they could be independently assessed, and that they obviously didn't allow that. But that would be a way of finding some way of being more, for the council to be more transparent about that information. I think that would make communities feel like they understood why, because at the moment they're just kept in the dark and they're saying, well, our experts have seen, and yes, this and that. When you dig into it, actually the reports are not, they are not totally saying this tree is causing this directly, you know. It's an implication.
Yeah, and that's all good points. I mean, taking your first one, so the fact that, you know, it's not compulsory, it hasn't been compulsory to sign up to the JMP. With the amendments to that that's now going ahead, that's why there's so much push on getting you know, government buy-in to it, and also trying to get the ABI, the Association of British Insurers, to buy into it as well, so that the governing bodies of both the local authorities and the insurance companies are saying, you know, this has got our seal of approval and we really want everybody to sign up to it. But it, you know, it can't be forced. But then what I would also say is that when you get to before a court, that you will have, when you go to court and you have a case before a judge, both sides will have expert evidence. Now that isn't, when I say expert evidence, I'm not talking about the evidence that's already been gathered and is being flying around asking people to remove trees or in defense of removing trees. That's not expert evidence. What I'm talking about is expert evidence is when the case is in litigation, both parties will appoint an independent expert engineer, an independent expert arboriculturalist, who will represent both the claimant and the defendant. Now, what happens that when that goes to trial, even where the defendant isn't signed up to the JMP, part of the process will be, and hasn't been in previous cases, is the standard of the joint mitigation protocol is discussed. You know, this is out there as an industry-wide protocol, you know, this is what should be expected, this is what should be done. So almost, you can almost think that when it gets to that, you know, the local authority won't be able to say, well, we're not signed up to it, so it doesn't apply to us. I just don't think that's going to wash.
Right.
So I think there's more chance that with the new revision, everybody will sign up to it because they're going to be pushed by the governing bodies. But even if they don't, when it gets to court, there's nothing stopping the judge saying, well, this is the standard that is being applied across the UK. So that's the standard that I'm going to consider should have applied here.
Could I just ask about JRs, actually, judicial reviews? Because I heard that the Plymouth group they've been allowed to go push for a judicial review of what happened with trees that were felled. Could any case law come out, you know, if it's really damning, what comes out of that JR, could that affect other cases with trees that perhaps aren't judicial reviews, but other court cases? Could that have any impact on how trees are seen in the courts, or if it comes to that, or even by councils?
Like possibly, like that's part of planning law. So you know, it's almost like in front of a different court,
right.
Under different law. And I'm not saying that that makes it totally irrelevant to the sort of civil law and the law of negligence and nuisance, but it wouldn't, I couldn't say it would definitely be. But obviously if there are tones and you know what I mean, if it's really pushing an environmental agenda, then I think it's likely that tone would be mentioned in a civil case. Like civil cases in the UK often refer to cases that happened in Australia or Canada, or, you know, different jurisdictions, which actually show a support for what they want to decide.
Sorry to interrupt, but I've got another commitment and I've got to leave. But thank you very much, Sarah, and I hope Gio will fill me in with anything I miss in the remaining part of the meeting.
Thanks. So we won't thank you, Glenn. So we won't take too much of your time, but this is really interesting. I was quite interested in our plane tree case. Well, not our plane tree case came to an end when they got their injunction and possession of the tree, but then the homeowner brought out a private injunction which went to the High Court. I don't know if you're probably not aware, and it sort of at the moment, Joe, you're really good. Would you be able to like just summarize where it's at and whether Sarah has any kind of view on why the parties wanted to were reluctant to go back to the High Court? I don't know.
I think, well, it was this was the house. Do you know the case, Sarah, about Oakfield Road?
That's the one in the press, is it? With the
Yeah.
tree,
There's been quite a lot in the
Harris fenced off with a security guard in it.
That's the one. Yeah. So, but basically, we were trying to object to the council's injunction when it looked like the council was going to get their injunction to stop protests at the tree, and hence the end of our legal process. The house owner that was implicated in the insurance case basically took out overnight his own emergency injunction to stop Haringey cutting the tree down, because he didn't want the insurers to walk away if the tree was cut down from. He really wants his house underpinned. It's a long-standing case. So he then initiated his own completely separate injunction to stop the council cutting the tree down, which stood, and that went to he was going to initiate a judicial review. That was originally rejected from the High Court, and then they appealed, and the appeal was upheld. And so that was moving towards a judicial review, but Haringey didn't want that, obviously, because it will incur costs and a lot more money, and they'd already spent a lot on this thing. So they settled out of court. But basically Haringey has stood down. They have removed any saying that they're going to cut the tree down, and they're going to reassess the situation. This is all in light of the Ombudsman's ruling, which still has not come, and we don't know what Haringey will decide. So that's and it's no longer our case, so we don't have any further information about that. But basically, and Haringey now have to give, I think, 28 days notice to the house owner if they decide they're going to fell the tree, with written the reasons why it's going to be felled.
Who said that? The Ombudsman?
No, the Ombudsman thing has not come out yet. This was the agreement, the outer court settlement between Haringey and the house owner.
So there's two insurers involved there, aren't there? Allianz and Aviva.
Yeah, because there's actually two buildings that are involved.
And then one of the homeowners is now objecting to the tree. So basically acting. So I presume both insurers are trying to get the tree removed, and now one of the house owners is saying no, we want it to stay.
Exactly. Crawford's is acting on behalf of both Allianz and Aviva. So it's a kind of stalemate, but the Haringey have had to stand down, and they will have to reassess, presumably, although we don't know, when the Ombudsman's ruling comes out, to reassess the situation.
The Ombudsman is an interesting one, because the Ombudsman, and this is just a point about the Ombudsman basically, is they don't have to follow the law or contractual terms, so they can make some quite wacky decisions, which is brilliant at some times, and then difficult at other times. It makes it very hard to predict what an outcome of an Ombudsman's decision will be, because they're not really bound by anything.
Right.
And make quite creative decisions.
They could quite possibly say that the Ombudsman ruling could say that the tree needs to come down. We don't know that, but I think our argument was that there should be a due process where a decision about the felling of the tree should be made after that Ombudsman's ruling has been done. And the insurers were putting so much pressure on the council to fell the tree before the ruling, presumably because the previous ruling said that the insurers should pay for an engineering solution rather than remove the tree. That's been our understanding.
Yeah, and we were really hoping it was going to go to a JR, because that was the case we were hoping was maybe going to, be one of the cases that could be referred to. But I think
Mm.
So it's been there's been lots of interesting stuff that's come out, and we could probably, it's not quite the case that we were hoping to kind of, get something on the case books.
Yeah. What about, have you guys ever tried, and I don't know whether this would work because it's relatively new, but making a complaint to the Office of Environmental Protection?
No.
So that's when I say relatively new, like it's existed, I think, for the last couple of years. And again, I think the seeds of that were planted in the Environment Act. So that is another complaint route to complain against a public sector entity. You have to, it has to be a breach of environmental law. So I think you would need to be making sure you were couching it in the correct terms. But I'll be interesting to see that starting to be explored for these sorts of complaints. I'm talking to clients about that quite regularly at the moment, but I haven't actually made one yet. And like the FOS, so the Financial Ombudsman, you could go on their website and search through past decisions, which can be quite interesting. You could search against Oaktree or Underpinning or something like that. So that can be quite interesting to do if you've got the time. But the Office of Environmental Protection as well, they'll publish their decisions, but obviously it's quite new, so there's not much there at the moment. But
that's part of the government. Is that a governmental department, or?
I think so, yeah. But yeah.
That's really useful and interesting to hear about. Yeah, and I know that one of our group made a complaint to the Forestry Commission as well. I think that was Ricky, wasn't it, Sarah? I think. But because it wasn't, no, that was to do with the McDonald's fellings. That was the 11 mature trees were felled at McDonald's down the road.
Oh yeah, and then didn't they build a McDonald's and say it was carbon neutral? Was that the one?
It was they just did it to make themselves more visible. I think they used all kinds of excuses about the tree. I think that was just, yeah, he apologized for it, the manager, but hey ho. But I think Ricky did, and if it's a big number of trees, unfortunately it didn't quite meet the quota, which is a shame. I think the quota should be shrunk, but they will help if it's a particular mass of trees. They can, but that's also fining. I think the fine should be so much bigger for these tree felling.
Are you talking that, so when you get in the Woodland Trust involved, are you talking about felling without a felling license and that breach? There is something like when they felled over a cubic quarter of, I don't know, there's a volume of wood that can be felled per quarter, and if you do it outside of that, you need a felling license.
Yeah, and so they can fine, but unfortunately I don't think it covered the right number.
Fine, like these fines are derisory. Like, if you've got a big developer or a big business, they'll just factor in the fines into their budgets. But what did change in England from January this year, the 1st of January this year, is that breaches of things like removing TPOs can be an imprisonable offence now. And that gives a little bit more of a scary factor, given that.
So what would be an example of that? So
I don't know. But I think it's if they remove a TPO tree and don't replant. I think it's something to do with the replanting thing can cause not only a fine but a risk of imprisonment. Joe, what are you going to say?
Sorry, just on that TPO thing, that just remembered. That was another idea that we've sort of discussed, which is quite a big idea, but just from a legal perspective, just wondering what your thoughts might be on turning upside down the TPO system. So instead of having to apply to protect a tree, trying to change the law so that by
all trees are protected.
All trees.
It's a bit like a donor card, so that everyone's presumed to be a donor, and you've got to opt out.
And you have to you then have to apply for a felling license to fell a tree, which would actually simplify the system for the admin in terms of the TPO. The local authorities having to deal with TPOs and
like there's so much talk about TPOs at the moment, and I would say, like, watch this space. I'm literally talking to anyone that I'm talking to about trees has got a question about TPOs, and I was in an interesting conversation with someone the other day who manages the Chancery Lane project. Now, the Chancery Lane project is a a legal project, and they create climate friendly clauses to be able to go into different business contracts, you know, whether that's construction, sale, you know, any contract. They basically build the clauses to allow people to go and get them, put them in their contracts, and make their contracts more climate friendly. Anyway, they're always on the lookout for innovative things to do, and I was talking to them about creating some sort of innovative TPO products to empower individuals to, I don't know, monitor, take action, whatever. But it's a conversation that he wants to start having. So it is a hot topic. It is a hot topic.
So Joe, maybe you should speak to the Chancery Lane project.
Sounds good. Yeah, sounds good.
And, yeah, I'm aware that we've got about 5 minutes left. I really appreciate this, Sarah. It's really useful to hear about all your kind of bits and bobs that you know about, as well as would anyone else like to sort of ask a question to Sarah about anything trees related, subsidence, or anything at all about the law, or I mean, Jane.
Have you ever been asked to brief a council or brief the tree department in a council about how they might be thinking differently about trees, given your knowledge of the law and given the fact that they're employing solicitors who have a very different viewpoint?
Yeah, so that's one thing that makes it tricky, and it goes back to Glenys's question when she said, are all insurance companies the same? I think, you know, you could say, are all local authorities the same? And they're certainly not the same, and they're not the same in their processes or what they do or how they work. So yes, I do act for a couple of local authorities that are really trying to change the way that they do things. I've got a couple of Welsh local authorities that I work for where, you know, previously subsidence claims weren't really bothering them because there weren't many, but, you know, we're starting to see, I'm based in South Wales, and we're starting to see the numbers of claims tick up here now because the weather's changing. So yeah, I think, Jane, yes, some are really forward thinking, and, you know, they all conversations that I have with local authorities, the vast majority, I would say if not all, are, you know, start from, we want to keep our trees. You know, we've got canopy cover targets. We love our trees. We want to keep them in the borough. You know, we're working to do that because they, you know, that's their ethos. It's just the financial risk of not taking action when they're being asked to can sometimes just push that over. But it's the local authorities that are driving this update to the Joint Mitigation Protocol, and the London Tree Officers Association and the Forestry Commission. So there's 4 of us on the panel at the moment. So there's local London Tree Officers Association, Forestry Commission, me. I think me and my sort of, with my Subsidence Forum hat on, and also my tree law hat. I sort of ditched the Subsidence Forum hat now. And then another gentleman who acts for local authorities in defending these cases.
Just 4 of you, but that's, you know, it's
that's 4 of us reviewing. I don't know how many have been involved in the past year. That's just the.
Are there any politicians you know of that are really tree friendly, like really pushing for trees, apart from Caroline Lucas, obviously, of the Green Party? Do you know any sort of figures, public figures, that are really like?
Oh, I'll tell you a good thing to look at. There's something called, oh God, what's it called? Climate, hang on, I'm looking at my other screen over here. I think it's called Climate Emergency. And there's a charity that have benchmarked all, oh no, that's not what they're called. They've benchmarked all local authorities across the UK on how they deal with claim, on how they deal with, I suppose, all parts of their business. And they rate them in a percentage basis. Oh, what's it called? I'm not gonna be able to remember what it's called. I'll remember and send it on.
Yeah, if you remember it afterwards, if you could email me, that would be great, because we've been in a very kind of oppositional position to our council for 2 years now, I suppose, because they've been doing lots of terrible things. But it would be good for us to kind of at some point start to try and change from a more kind of progressive, you know, trying to think, well, how can we move forward? How can we, you know, emoliate? How can we start being friends more than, do you know what I mean? Because we don't want a very tiring, exhausting position to be always fighting, you know, for all of us. And and sometimes you have to fight a lot at the beginning, but we do want to start talking, like having really productive kind of, you know, communication. It's kind of tricky, but maybe things like I mean, all the new stuff it's all about new planting. That's the sexy subject. That's all they want to talk about. But we're all about trying to protect what we have, you know, the existing stock. And it's trying to build on that side rather than all this new planting and the canopy cover, which is the contradiction. If you're incrementally felling trees for different reasons, you're losing the mature canopy cover. It's trying to slightly turn our council around, but we're finding, I mean, lots of environmental groups in Haringey are finding the same thing, that they're just coming up against a brick wall, you know, and there's lots of really positive stuff going on, but it's trying to work with our councils. If we could somehow, you know, get them on side a bit more, you know.
I think when, you know, when I said in the last 6 to 12 months, you've got insurers and local authorities that are really wanting to meet and chat and understand each other's position. It's almost like the general public is the missing link in that conversation, and you know that it needs to be a three-way conversation rather than, but they're yet to have the two-way conversation. So you know, I think things are changing, and I think people are going to be, you know, demand, you know, fast forward, you know, once the duty to consult comes in, and the more of these cases that start hitting the press and causing huge annoyance factor, that's when you're going to start being invited to the table more, I think, to have discussions.
Yeah,
it shouldn't need to take that, but I think that's what it might need to take.
And trees are much bigger news now. There's so many tree stories. We heard St Albans council want to fell 250 trees in a residential area, and the locals are really up in arms about it.
The
reason they're saying a lot of them are diseased, but the locals are saying they're not convinced, and that's 250 trees threatened in a lovely community, you know, residential area. And I think, you know, there's more cases that we're hearing about, so the tide has got to turn. It's just got to turn more quickly. That's the thing. But I don't know if anyone wants to make a last question or point, because we'll let Sarah go, because she has been with us for like an hour and a half. I could go.
Okay.
I never thought I'd be talking about subsidence and the law like 5 years ago. Here we are. But if anyone wants to, anything else that people would like to add or ask.
I mean, you'll have my details like as well, so you know, hang on, I'll just put my details in the chat.
So if we ever needed a little bit of advice from you, I mean, we have a little pot, but we could, do you sometimes give advice to environmental groups, sort of as a kind of, you know?
Yeah, I was talking to another London-based environmental group earlier on this week, actually. I can't remember their name, but I wouldn't mention it anyway, just in case. But yeah, I certainly could do.
Because sometimes that we have sort of, you know, I'm sure we'll be involved in another case soon. Oh God. We're really hoping the Oakfield Road plane will be saved, and we can, like, you know, send it out to the airwaves, you know, and like say, hey, we won a case. It would be brilliant. But there's so many other trees that are threatened. We have 200 cases or more, insurance claims. I think it will probably be more in Haringey at the moment. Not all of those are live, but they potentially could go live. So we've got a lot, because we're on clay soil. It's really,
it's a hotspot area. Haringey is a hotspot area.
Really. And another thing we were saying to our council was, why couldn't you get together with Haringey, Camden and Islington as a kind of tri-borough kind of like, and try to speak to the insurance industry and say, hang on, we're on a clay soil, of course we're going to get loads more claims. Haringey says it's got some of the highest claims in London, and I don't know if they're doing that, but I think that would be quite a good thing to do. That the insurance, it seems really unfair to, you know, to target councils that are on such tricky soil, you know, like notorious. Yeah.
If there's something called the Clay Research Group, and I'm not giving an opinion as to what they're like or not, but they produce a newsletter where they focus on different areas in the UK for their susceptibility to subsidence claims. Now your area will be focused in there. If you want to trawl back through all the online editions, but that can be useful to look at, as it tends to have like a heat map picture showing like where, because it won't be a hotspot throughout the whole of your area. There'll be areas that are more risky than others. It can often be streets more risky than others, and that's why when you think, right, if you do have to roll out quite a harsh tree maintenance program, then at least roll it out only in the red zones, leave the green zones alone. But yeah,
that's good. You've given us loads of tips today. Thank you so much. Just like brilliant. Little round of applause.
That's okay.
We really appreciate you coming along, and yeah, just we'll keep you posted as to what we're up to as well. And yeah, hopefully Wales won't be flooded with insurance claims.
Well, I had a conversation with somebody up in Leeds, or around Leeds, saying, we need to find out some more about subsidence, because we're starting to see these case numbers tick up and up and up here. Areas that haven't experienced them because climate's changing and then they're moving.
Yeah. Well, I guess the insurance industry has to move too, and it has to realise that it fell all these lovely healthy trees. But anyway, thank you everyone for coming. Really appreciate it. Thanks for all your time, and Sarah, and lovely to see everyone. And I can send the recording out, I think, to everyone if you want to look back on it, or so I'll close the meeting down now. No one wants to discuss anything for HTP. I think we're all kind of need to have something to eat now, right? Okay.
Thanks, everyone.
Bye, Sarah. Take care.
Bye.
Thank you so much. Bye. Bye.